Hi, very good morning. Again, a Supreme Court judgment under the Customs Act. Global Technologies and Research versus Principal Commissioner of Customs. Facts. Global Technologies and Research, we will call it as GTR. GTR is regular importer of goods. He imported a consignment of goods. To be more precise, camera stabilizer devices. He filed a bill of entry, GTR filed a bill of entry and invoice of a Chinese company. Goods were examined by customs and they alleged that the goods are grossly undervalued. Hence, customs detained on the ground of misdeclaration and undervaluation. Then the customs authorities they saw the past imports based on the data available on the computer and found that GTR imported identical or similar items with the same model at higher prices. The submission of GTR was that goods imported is supported by one manufacturer's invoice. Manufacturer is not related to me. I am producing a manufacturer's invoice. So the if the manufacturer is unrelated, that price declared by the manufacturer has to be accepted. That is one submission. Second, value of goods was listed on some well-known online trading and B2B websites. So they showed the exact value in which they are selling it to different people. Third is letter was produced from the manufacturer that the goods imported were of lower version. So even though similar goods or identical goods were imported, that was of a better version. Now this is a lower version. So customs conducted a market survey. They did not accept this. They conducted a market survey. Then as usual notice issued. Order in original was passed against GTR. Penalties were imposed. GTR filed appeal before Commissioner of Customs. That was allowed. Then the appeal order was examined by the Committee of Commissioners and they directed to file an appeal before the CSTAT. There was some delay in filing the appeal. CSTAT allowed the appeal of the department. So against that order, GTR filed appeal before the Supreme Court. There were two issues before the Supreme Court. One is whether the appeal filed before CSTAT was time barred. The second issue was whether there was undervaluation of goods and the penalty imposed is correct. On the bar of limitation, Supreme Court noted that there is no specific period prescribed under section 129(2) of Customs, 129 I think A2 of the Customs Act for the Committee of Commissioners to exercise such power. Supreme Court said, so they examined the provision and they said there is no time limit prescribed for the Committee of Commissioners to exercise the power given under the Act to file an appeal. Supreme Court said it is true that even if the law does not provide for a specific period for taking a particular action, the authority vested with the power to take action must take the action within a reasonable time. However, in the present case, the period fell under COVID-19, that pandemic which was there, and Supreme Court also passed several orders extending the time limit. So hence the delay was condoned. That is the delay, the appeal was not barred by limitation. That is what the Supreme Court said. Then on the issue of undervaluation, Supreme Court refused to interfere on the factual and the detailed order passed by the CSTAT. Supreme Court relied on a statement made by one of the officers of GTR that there is little difference in the hardware and software uh, in the disputed goods as compared to the earlier versions that were imported. So one of the officer, it seems, he made a statement saying that there is no difference, absolutely no difference between the hardware and software functions of the present goods which are imported and the past goods which were imported. So Supreme Court noted that both order in original and CSTAT order cogent reasons were given to reject the value declared by the GTR. Hence, it said, I will not interfere with this order. And then they rejected the appeal filed by GTR. Two interesting comments. One is Supreme Court had a dig at the advocates for making a brief submission of 35 pages before CSTAT. So earlier childhood days, whenever I was in fifth standard or sixth standard, when the question paper comes, when they say write brief answers, I used to write some 4 5 pages. Similarly, it seems the advocates have made a submission, a brief submission of 35 pages before CSAT. So Supreme Court specifically quotes brief within the court. The second one is one of the submissions of GTR was that the goods were of unpopular brand. This was rejected by Supreme Court, maybe due to detailed order passed by CSTAT, because that order has not been recorded in the judgment. But in my view, this is a very, very important question. Branded products command a huge price as compared to unbranded or unpopular brands. It's a fact of life. Go and buy any popular brand, see the price, and of the same quality of this, you can buy another article of the another product, unpopular brand or not branded, then the cost is much much lesser. So you can see the difference. But this question, I don't know whether it was addressed by the CSTAT in its order. It's an important question, is my view. Thank you very much. Have a great and wonderful day.